Now move to the second case on our docket today. Citizens of the State of Florida versus Brown.
May it please the court, my name is Charles Ray Winkle, and together with co-counsel Stephanie Morse, we represent the customers of Florida Power and Light in this matter. Your Honors, we are here today because Florida Power and Light broke the law by polluting the Biscayne aquifer, and now FPL wants its customers to pay for its attempts to clean up the damage it caused. The PSC erred in its construction of the governing statute in an order that would require the customers to pay to clean up the damage caused by FPL's violations. This is a clear error under the plain meaning and plain language of the statute, and it requires reversal. So far, FPL has dumped nearly 7 billion pounds of salt miles into the state's waters beneath the eastern edge of the historic Everglades. That violated not only FPL's permit, but the applicable rule and the statute governing water quality in that area. Page 8 of our brief contains FPL's own evidence demonstrating the scope of the damage that they caused to the aquifer. The Commission allowed the use of an otherwise effective, specialized statute rate-making clause in an unlawful manner to protect the company from absorbing any of the costs to try to undo the harm that they caused with all that salt pollution. We ask you to instruct the Commission that the plain language of the law requires that when a utility harms the environment and then attempts to reverse that harm, that the environmental cost recovery clause bars customer recovery, because those portions of the consent documents requiring cleanup of the accumulation of some 45 years of salt damage does not meet the specific statutory definition of a regulation that is designed to protect the environment. Otherwise, Your Honors, we submit that such a result would create a perverse incentive for utilities to make little or no effort to comply with existing pollution regulations. That's because, as it stands with this order, if a utility gets caught polluting, admits to breaking the law and causing the pollution, and then cuts a deal with an environmental regulator requiring it to clean up its own pollution, it reduces the jeopardy that that company has for polluting.
Yes. Hypothetical clearly has nothing to do with what we're talking about today. If there is a briefcase with a ticking time bomb outside of a building, and I order a government agency or I order a private entity that's regulated by a government agency to clean up that ticking time bomb or to move it, am I, in addition to cleaning up that mess, protecting the people that are inside of that building?
Well, Your Honor, I believe if the bomb hasn't exploded, you would prevent the harm from occurring and thus protect the people. If it has already exploded and it was out there because of some unlawful activity, and there was the protection couldn't occur. You can't restore the life or the damage that has already occurred. You can only attempt to repair it.
Is it the citizen's position that 3 miles of salt inward from the coast is not a ticking time is not a ticking time bomb for the remaining portion of the aquifer that has not been salinated?
Yes, Your Honor, that's an excellent question, and I would answer it this way. Both consent agreements that we're talking about, the Durham agreement and the DEP's agreement, they sharply distinguish between two types of activities. One, to prevent additional harm, and one to clean up existing harm. And we agree and we acknowledge that our obligation, our client's obligation, the customer's, is to pay for preventing any further harm. If you look at that green picture, that picture that we've included in page 8, there's a red mass. It kind of looks like a rabbit if you kind of look at it. Everything to the west of that that's in the green, that still hasn't been harmed. And we agree we have to keep that from being harmed.
So what I'm asking, and I understand that, what I'm asking is, if nothing is done for remediation, I'll use the terminology that's been used, the remediation, does that green blob or the red blob affect the green blob?
Maybe, maybe not, because the abatement provision, which says you have to dilute the salt in the cooling canal system, it's intended to halt the progress. And that's a containment function that we have to pay for.
But
so even if you don't clean up...
But counsel, doesn't that only work if you take out what's already there? In other words, I understand that stopping further intrusion stops it. But if you leave in 3 miles worth of salt, does that salt not further migrate out into the aquifer?
It doesn't if you freshen the source of the salt and you stop the process that's pushing the salt out, which is this pump that the hypersaline water comes out of the canal system. If you stop that, the rabbit's not going to grow in size, and there's not going to be an additional harm. And we agree we have to pay...
So you could leave the bomb there as long as the bomb doesn't go off? To use my terrible analogy.
Yes, except that the requirement in this case, the law requires the bomb to be removed. And the removal and the cleanup is what isn't protecting that part of the environment that's already damaged. You can only try to restore that. We agree that if you take the measures that are required and they work, that stop the process from moving, then protection occurs, and we have to pay for that.
Well, let me ask you this. Was there any evidence in the record to suggest that if there was no remediation of the 3-mile intrusion of salt, that the rest of it would be unaffected as long as there was the plan to put no further salt into the ground?
Your Honor,
was there evidence that if the briefcase is there with the bomb in it, that further intrusion down the line in the aquifer would in fact happen?
Your Honor, I don't believe there is evidence of that. I think the evidence is actually the other way, is that the freshening actually facilitates the cleanup. So to the extent that you're freshening and you're putting less salt in there, it will make it facilitates remediation. So there's some sort of overlap there, but there's no evidence that says that the cleanup is something that facilitates the progress of the plume. The plume is caused by what's going on in the canal system and how it relates to the hydrology of the aquifer.
If there's no cleanup, is there continuing harm?
If there's no cleanup, yes, there is. Paragraph 37 of the consent agreement says that essentially that the DEP is holding in abeyance their ability to pursue penalties for the harm that's caused. FPL is required to fulfill the obligations and to do the cleanup or be subject to further penalties or to be subject to penalties. So that's kind of in abeyance, but they're required to do it. And the harm would continue.
Let me ask you a question related to that. What do you say to someone who would suggest that your understanding of the term protect is simply too narrow? That there's a commonly understood meaning of that term, which is to take care of. You protect something, you take care of it. And further that, when we talk about environmental laws and regulations, the notion that the aspects of those laws that require corrective action to be taken are not measures designed to protect the environment, just kind of flies in the face of the way we would commonly understand that. It just seems to be somewhat detached from reality. What would you say to that?
Well, Your Honor, I would
say... I know you disagree with it.
Yes, yes, Your Honor. I would say to that is that the environment is multifaceted in this case, and the environment that is to be protected can be protected. The environment that is harmed can't be protected. They can only attempt to repair it. And it is
But
very
how is
clear.
that- But how is that not protecting it? If you remediate it and you repair it, how is that not protecting the environment?
Well,
I guess, is your position in essence that once you damage the environment, you can no longer protect it by remediating it?
well, Your Honor, you can't protect it until you clean it up. And Mr. Soul even testifies to that when he's addressing a question to Mr. Pullman in the hearing. Is he was saying that after cleanup occurs, then containment can happen, and that will be after 10 years. But in those 10 years, you're only trying to benefit or improve the environment. That's different than protect that the legislature set out. And you have to look at the context of when the 1993 law was passed. The Clean Air Act amendments were coming down, and they were saying we need to put less pollution out into the environment and put these scrubbers and other mechanisms on the utilities and protect the environment that way. And because the word protect means to prevent the harm in the first place. So you're keeping those emissions from going out, and that's the context that the law was adapted under.
But it seems like your admission is that there's continuing harm. So if the cleanup must occur to prevent continuing harm, why is it then protecting the environment?
Well, the continuing harm is to the aquifer that is being damaged by the progress. If you're talking about the static mass of salt that's there, while it's there, it is that water that is moved from G3 to G2 is unusable for any purpose.
But it seems like this environmental event is not containable by itself, so that there's no continuing harm or exposure or harm that needs protection. It's not a situation where the damage has been done, it's not going to do any more damage, it just needs to be cleaned up, and there's no more protection to be done. That's not the case here, it seems to me.
Well, I may have misunderstood your initial question, but where that red mass sits that needs to be retracted, that damage is extant and it's not changing. What's changing is if it keeps moving. And there's a separate mechanism that protects the unharmed environment by saying that you're going to put less salty water in that aquifer and stop the progression. There's a clear delineation in both documents between cleaning up existing harm and preventing future harm.
Isn't the testimony, though, and I think you referred to it, that if you pull it back for long enough, I think it was 10 years, the plume would retract. Isn't that the testimony?
The effort is to pull it back, and then they have to get it back to the L31E boundary within 10 years. After 5 years...
So it's not permanently harmed, as you've just had the discussion with Justice Polson. The plan is, whether the plan works or not is a different story, but the plan is to get that water beyond that boundary to where it was beforehand.
That's the intent. There is, even the company's hydrologists agree that for the aquifer that is designed, that it was defined down to 100 feet, they can't get it all back. So there's quite a bit of uncertainty whether they can actually repair all the harm. And what they did is they tried to redefine the aquifer to be something that didn't include what they can't get back. But I think it's Exhibit 74, it's Interrogatory 23. They show that the aquifer goes down to 102 feet. And that 102 feet, the testimony is uncontroverted. They can't get all that salt back. So they can't get all of the harm repaired. That's the intent. But until they get it all back, they cannot say they have restored the aquifer to the state that was required in 1973 onward, that they not put salt in there to the west of the cooling canal system to the extent that it wouldn't be there but for the existence of the cooling canal system. That's the state they have to restore it to.
Let me ask you a follow-up to my earlier line of questions.
Yes.
Are you familiar with the Superfund Act?
Somewhat.
You know generally what it
Yes.
does. Would you based on your argument here about the meaning of protection and protect, would it be your position that the Superfund Act is not an environmental protection measure?
The Superfund Act, in some instances, may generally be environmental protection.
But then basically what the Superfund is about cleaning up polluted sites.
It is, and it's about restoring the sites. I would not assert that in every event that a requirement under Superfund would be eligible for cost recovery under the Environmental Cost Recovery Clause. The ECRC is not the only way they can recover these costs. They still have FPL still has the ability to go and seek recovery in a base rate case. Remember, the ECRC was specifically designed by the legislature to be a non-rate-based recovery mechanism that would avoid the need to keep having rate cases every time an environmental regulation came down.
Excuse me, could we circle back to the policy argument that you started your
Yes.
argument with? And you were talking about sort of what you're calling the perverse incentives here that would follow from the other side's position. And I guess their response to that is that it's only prudently incurred costs that could be recovered. Could you address that argument?
Well, the prudent standard in the Environmental Cost Recovery Statute is only the cost that you actually have to incur in the future to meet your obligation under the rule. They don't have anything to do with what happened the last 45 years. This is specifically, did you spend the right amount of money on drilling the wells?
I don't know why you say that. I mean, if through misfeasance or malfeasance an electric utility damaged the environment, then I don't know why that wouldn't be imprudently incurred cleanup costs. And you seem to be suggesting that otherwise.
The Commission's orders all only talk about the costs that you are spending in compliance, not the reasons you got there. It's just and that's the way the statute reads. It's those costs that you incur to meet your new obligation. And that's the only prudent standard that's in that statute.
You may certainly continue.
Okay.
You have.
I know I'm well into my
most of your
time. I'd like to
rebuttal time.
reserve the remainder of my 3 minutes, Your Honor. Thank you.
Thank you.
Good morning. May it please the Court, I'm Samantha Sabula, and I represent the Florida Public Service Commission. I'll be sharing my time with Stuart Singer, representing Florida Power and Light Company. I believe you've hit the nail on the head in regard to the issue here. It's a prudence determination, and the Commission made that prudence determination. They reviewed all the information that OPC has raised about whether the utility company broke any laws in regard to the operation of the cooling canals, and the Commission found that no, they did not, and that they acted prudently in working with environmental agencies and getting, in response to the consent orders, and doing what they were told to do by the environmental agencies. Therefore, their costs are appropriately recovered under the statute.
So in other words, if you had found that the cleanup costs were necessitated by misfeasance or malfeasance on part of the electric utility, it would have been imprudent and you would not have allowed the recovery.
Correct. We considered all that information, and our review showed that there was no point during their operation of the plant that they deviated from their permit until the notice of violations occurred. And as soon as they did the notice of violations, they responded to the environmental agencies to come up with a plan to fix the problem. And therefore, based on our review of this information, we determined that their costs were prudent and that they should be allowed cost recovery. And actually, there was cost in there that we didn't allow cost recovery for. It had to do with $1.5 million that they put into an escrow account that was supposed to benefit the state of Florida in general, not specific to FP&L customers. And the Commission didn't allow cost recovery for that amount, finding that it wasn't prudent. So we did review all the information, and we found that it was prudent and they should have cost recovery under the statute. And in regard to whether or not they broke the law, and that should be a basis for whether or not that they should automatically be found not to be prudent. There's a case called Florida Progress Corp. that says that the commission, which was a Florida Supreme Court case, that said just a notice of violation itself is not enough to say that a company acted imprudently, and that we'd have to do our own independent prudence evaluation in regard to determining whether or not companies acted prudently, and that's what we did in this case. It's not the same statute, but the same concept is there. And as was shown is that OPC's definition is a very narrow reading of the statute, and even the record itself showed that it would be difficult, if not impossible, for the commission, as not being a regulatory agency, to distinguish between remediation and containment measures and what we should allow cost recovery for in that regard, because it's not always clear. Sometimes a remediation measure is for containment, and us not being the environmental agency, we would be in the position of trying to figure out, well, if it has remediation and containment, should we allow cost recovery for it or not? So it would make it very difficult for the commission to implement the statute. And the legislature is the one that made the policy decision to allow cost recovery under the statute, and told us to make sure that the costs were prudent, and that's what we did in this regard. Unless there's any other questions, I'll turn it over to Mr. Singer.
Mr. Chief Justice, and may it please the court, I'm Stuart Singer here on behalf of Florida Power and Light Company. I'd like to begin by noting that this distinction which the appellant's argument rests on between efforts that are directed to preventing environmental harm and those that abate and repair harm is not found in the statute for environmental cost recovery. And they struggle to try to draw a distinction that, frankly, I can't see and we believe you can't see between the language designed to protect the environment and environmental protection. The statutory authorization we are here on is broad. It talks about environmental cost recovery in terms of, quote, all costs or expenses incurred in complying with environmental laws or regulations. It doesn't say environmental laws or regulations to the extent only that it prevents future harm. Those, in turn, are defined as all federal, state, or local statutes, administrative regulations, orders, and I would suggest orders by their nature deal with things that have occurred, or other requirements designed to protect the environment. All statutes, regulations, and orders. Again, expansive language. What the statute does not say is what the appellant puts in its reply brief, that this is limited simply to new unanticipated regulations between rate cases. That's not what the statute says.
Counsel, I'm concerned about the evidence.
Yes.
So assume that I agree with the citizen's reading of the statute. What evidence was there in the record that the remediation plan, the cleanup, however you want to call it, would in fact protect the remaining portions of the aquifer?
There is evidence in the record which supported the prudency. Let's look at what was done. There are consent actions to create a recovery well system, an aquifer well system to provide 14 million gallons a day of low salinity water and extensive monitoring. And those actions, according to the available data, and this is in the record, have already reduced salinity with 890,000 tons of salt being removed, with evidence showing that the westward migration of this salinity will be stopped within 3 years. That retraction would start in 5 years, with a return of this salinity plume within a decade back to the boundaries of the Turkey Point facility. So there is ample competent evidence in the record supporting that this was, and these measures were, of course, done together with the regulators. This is an FPL just saying these are things we're going to do. This was worked out with the South Florida Water Management District, with the Department of Environmental Protection, and with Durham. And these were agreed measures. And these agreed measures are supported by competent, sufficient evidence in the record that the Commission has accepted that this will work, and there's evidence that it is working. So with respect to evidence, we think that the decision here that these were measures entitled to cost recovery is clearly supportable. And I would note, in agreement with the question that the court asked, that it is that test of prudency which prevents the parade of horribles that appellant is concerned about. We agree with what the commission stated, that if the utility is acting in a wrongful manner, misfeasance or malfeasance, then that affects the ability of a prudency determination to allow cost recovery. But that's not what this record shows. There is no evidence of that. None of the agencies have found any misfeasance or malfeasance, nor has the commission, and their evidence is not there to support such a finding. I would like to go back to the statute to make one additional point that I think is significant. That here, following the doctrine of imperi materia, it is important to look at environmental cost recovery in connection with the Pollution Control Act in Florida, because that is exactly the act which creates the framework for which these measures are being taken. The Environmental Cost Recovery Act talks about actions in section 403.021 for prevention, abatement, and control of pollution as the purpose of the act. These are right up front and are repeated many times. In a very narrow section with respect to certain measures, there's a separate definition in 403.0318 that talks about pollution prevention, which are defined as steps taken by a potential generator to eliminate pollution before it is discharged into the environment. So that means the legislature knew when it wanted to write narrowly about solely preventative steps how to do so, and when it wanted to write broadly about environmental protection, that it includes measures to prevent, abate, and control pollution. And it makes sense to interpret the environmental cost recovery statute together with the imperi materia with the regulatory structure that creates the regulations and the orders under which cost recovery will be sought. Now,
So is it your position that the statute would apply even in the circumstance in which an environmental event occurred that was totally contained and there was no issue, as they argue, about a continuing harm or likelihood of harming the environment in some way, just the act of cleaning up a problem created to the environment by itself that's contained would be a protection event under the statute?
yes, it would. We think that environmental protection includes prevention, it includes abatement, it includes control and remediation. You can't separate these.
Well, their argument, it seems like, the legislature could take a position that a contained event like that should maybe reasonably be borne by the company, its insurers, the shareholders, someone other than the folks paying their electric bill.
I would agree, Your Honor, it would be possible for the legislature to draft a statute in that way. They have not done so here with the environmental cost recovery statute. It speaks broadly about measures designed to protect the environment. And all the examples which were discussed with appellant's counsel, I think shows that you can't draw this line between prevention and control and abatement. That cleanup actually helps prevent continuing harm. That retracting the plume is the same as removing the bomb that's ticking but has not yet exploded and created greater effects. And the Superfund Act serves to protect the environment by cleaning up sites that are contaminated. And it would be very strange to consider any of those measures not to be measures designed to protect the environment. And in fact, counsel admits in his argument, I think his exact language was, there is some form of overlap. And given that there's that form of overlap, we don't see where some distinction could be made as a matter of law that the statute doesn't extend to measures that create prevention.
Mr. Singer, I should have asked this of the commission. I didn't. Do you have any thoughts about how the traditional deference that this court has given to the Public Service Commission's interpretation of laws within its regulatory jurisdiction is affected by the new constitutional amendment that says that courts of the state shall not give deference to agencies in matters of statutory interpretation?
Yes, Justice Lawson. We think that that does affect the interpretation of the statute part of the case. That there the standard is now de novo review, and that type of deference to the interpretation of the statute or rule is no longer appropriate in light of the constitutional amendment. However, we think two things. One, that the court still can consider the persuasiveness of the reasoning by which the Commission has considered a particular statute for purposes of its interpretation. And second, we think that deference is still fully intact with respect to the prudency determination, and that is not in any way affected by the decision here. Unless the court has further questions, we submit on the papers. Thank you.
Thank you.
Thank you. I want to address the issue of overlap. The only overlap I was talking about really goes the other way, which is that some of the containment that we're going to pay for actually facilitates remediation and probably makes it a little cheaper to do. But that's kind of beside the point. The legislature had, as FPL and the Commission have proven in Paris, they knew what environmental protection meant. In 1910, in St. Paul, Minnesota, where they published Black's Law Dictionary, they knew what environmental protection was. But they used a specific word that says designed to protect. They could have put the phrase environmental protection in there. They could have said intended to benefit the environment or improve the environment, but they didn't do that. The strict language of this statute was put there by the legislature. And what the appellees are suggesting is that you ought to reinvent that and then go and interpret it in a way that suits their narrative. And we think that's wrong. The plain language, Your Honor, in this case controls. And we would submit to you, if you take this broader interpretation, this expansive interpretation, you write the specific words out of the statute. You take that clause, that provision that the legislature put in there, and you make it meaningless because it just environmental laws generally.
Would you agree that protect the environment could mean protect against future harm, which is your argument?
Yes.
Would you agree that it could protect the environment could mean protect against continuing harm?
Yes, but the continuing harm here is the migration. You can't, the salt sitting there makes that part of the aquifer.
Would you agree that it could mean protect against all harm?
Your Honor, I think that the word protect has a very specific meaning that means it prevents the harm in the first place. And I think that's what you're proving.
So you do think it can only mean protect against future harm?
Yes, Your Honor, that is our position.
Okay.
Yeah. We ask you to reverse and remand this case, and we forward instructions for the Commission to follow the statute as written by the legislature. We also ask you to pay special attention to that 2009 order, which we believe could not have legally or reasonably made a prudence determination about costs that would be incurred some 8 years later. There's the problems that would incur would be indeed detrimental to utility rate making. But I appreciate your questions and thank you for your time, and we ask you to reverse the case. Thank you.
Thank you.
Thank you. We thank you all for your arguments. The court will now stand in recess for about 10 minutes.
All right.